Welcome back. The Chief Electoral Officer of the Electoral Commission, Simon Mabolos, told the Electoral Court that the political party Umkhonto weSizwe has not produced any evidence to support its claim that 9 million votes were stolen or miscounted during the elections. MK claims the vote was rigged. As yet, it has not provided any evidence in public of its claim, but it has provided a document from a person they say is an expert. That person disputes the tallies the IEC arrived at for different parts of the vote. Benedict Phiri is the Managing Director at Iusprudentia, Specialist Counsel. Benedict, good afternoon to you. So, when you bring an application in a court, in this case the Electoral Court, and in this case it's to claim the election was rigged, what kind of evidence would you have to bring? I suppose the question may be, what constitutes evidence?
Good afternoon, Stephen, and good afternoon to the viewers. When you bring an application, it's always based on papers. So the court is never going to have regard to the evidence of people that are standing in the dock or given oral evidence. So all the paperwork that you attach to your application has got to be evidence that speaks for itself. And that can corroborate or essentially persuade somebody that what is there is genuine, is authentic, is real, and can actually sustain a set of facts. So in this particular instance, what the MK party was required to do was to show cogently instances of vote rigging. And what they've actually done is they've resorted to what they call some kind of a report, which basically tries to ascertain the instances in which the voting process could have been compromised, but without actually pinpointing where that could have been the case. And they've also relied on certain sort of instances where people have said that there's been instances of vote rigging, but none of that is actually under oath or in a format in which the court can take cognizance of. So in this particular instance, their application is very lacking insofar as evidential detail is concerned.
As I understand it, so MK say they have a document from a person they claim is an expert that shows some of the counting was wrong. They do not name the expert. You would have to name the expert, right? And how would you prove that an expert is an expert? Would you have to bring qualifications?
Yes. So whenever you want to introduce expert evidence into court, you have to qualify the expert. So you have to actually say what is the curriculum vitae of that expert, what kind of work have they done, why are they an expert in this particular instance that the court can actually take into account or elevate their opinion from a simple opinion into an expert opinion. In this particular instance, that expert, we don't know who they are, how they qualified to do this particular work, how they actually derived at the outcomes that they've come at. And we know, for instance, that the IEC has challenged very strongly the manner in which that expert has gone about its work and actually the data sets from which they actually have derived the conclusions or potential conclusions, because it's all summations and suppositions at this point in time from the experts and no conclusive outcomes from them. And the IEC has a very simple explanation for all of it all. So I think, wherever that expert evidence comes from, I think it can be taken with a pinch of salt.
I would imagine, this was a national election, right? Millions upon millions of votes, 9 provinces, lots of different places, some voting stations you could only get to by boat. What I'm trying to get to is if you were going to bring evidence that 9 million votes were lost or miscounted or something, it would be a lot of evidence. It wouldn't be one person. You would have to bring quite a lot of evidence, I would think, to make a claim, because it's a very weighty claim which is being brought, a very serious claim.
Absolutely, Stephen. You'd have to show some materiality. You'd have to show that what you saw in one voting station, for instance, replicated itself across a number of voting stations and districts in a manner that could materially affect the outcome of the election. And none of that has been suggested in any particular way or shape or form, or in a way that can be persuasive in this particular instance by the MK party. So certainly, I don't think, in reality, this was meant to be a legal case that was meant to stand on its own twos and see itself through the legal system. I think there might have been a reason to bring this that had to do with maybe political issues or maybe trying to plant an idea around the fact that these elections may not have been free and fair. But certainly from a legal perspective, I don't think anyone can seriously say that this application was meant to go through the whole way, through the entire court system.
Can a court, I mean, if someone brings an application, very serious application with no evidence, the IEC seems to suggest, if I've understood them correctly, they're kind of with you on this, that they seem to think there was another motive here. It wasn't a legal motive. I mean, can a court take any action over that? I mean, everyone has a right to bring a case to court, I suppose.
Yeah, everyone has a right to bring a case to court, Stephen. You know, I think if the court finds that it's substantiated, that there may have been another reason that this matter was brought to court, it'll certainly come through in their judgment. You know, we have seen the courts remark on instances where matters have been brought to the courts in a manner which they shouldn't have brought on, and the courts have shown their displeasure around that. So certainly something like that will see its way into the judgment to the extent that the court is convinced that that actually is the case.
Benedict Phiri, as always, thank you, Managing Director at Iusprudentia Specialist Counsel. Really do appreciate your time on this.